Welcome, everyone, to this next session for the Berkeley Center for Law and Technology's NIL series. Once again, Ksenia Maiorova is with us to lead our own from Berkeley, actually, to lead this session. And I have to point out that, in addition to being one of the nation's leading experts on immigration and sports law generally, it was really part of the pioneering group, and you're going to get to meet the other half of the pioneering group here shortly of NIL and immigration issues, how it's really affecting student athletes, and in surfacing issues that maybe never were really raised in the beginning when we started talking about NIL that tend to impact lives and families in ways that people just didn't think about. So maybe out of that, a lot of volunteer work, and definitely a lot of volunteer work for Berkeley and for these families around the country. So I want to thank you, Ksenia, and now that I've met your partner, thank you to Amy for joining us and for also getting involved in volunteering your time on this. So with that, Ksenia, I'll let you do the introductions of your partner.
All right, fantastic. So it is my pleasure to introduce Amy Maldonado. She's the founder and principal of the law offices of Amy Maldonado. She's based in East Lansing, Michigan. And she is a friend and colleague, someone that I have collaborated with and brainstormed with on sports immigration issues for more than 10 years now, I believe. And Amy is someone who became, sort of my thought leading partner in this area of NIL and the intersection that it has with immigration. So Amy and I were sort of dumped into the NIL era. I think because we already both had established practices as sports immigration lawyers. We were representing primarily at the time athletes who were not in college, although some of my athletes were in college and sort of transitioning out to their first post-collegiate career. So when NIL happened, Amy and I naturally received a lot of questions about what is the impact of NIL on international student athletes. And we were among the first, I think, to come out and say that this is a major problem, that the F1 restrictions meant that the NIL opportunities were not going to be universally available to international student athletes on par with their US counterparts. And as we began to explore this issue, we also started thinking about, well, if we can't do something with them while they're on the F1. And this is something that we sort of explored in our first couple of modules here in the series about the limitations of the F1 and the possible workarounds and really the risk involved with those workarounds, right? So what Amy and I started thinking about is, okay, how can we diminish the risk? Is there some other immigration category that we can silo these athletes into that might give them access to NIL in a way that is less risky than trying to do workarounds on an F1. And I think the way that I came to it, and I'll ask Amy about the way that she came to her ideas on this, is that I frequently represented track and field athletes who were sort of at the end of their NCAA eligibility, but had a little bit of scholarship money left over and were pursuing master's degrees. This is all pre-NIL, right? And so they would come to me and, try to identify the most appropriate visa category. And for some of these folks, they were, either already signing professional contracts or were on the verge of signing professional contracts. So it really wasn't appropriate for them to stay on an F1 anymore. And what I did with those folks while they were still in college, right, because they're still going to class, they're still getting their master's, is I moved them to P visas, which would allow them to, focus on their track careers, sign contracts for professional sponsorships if those became available to them, and continue to go to school. And the reason why I knew this was workable was because I had done it before, and there's some guidance that goes back to, I believe, 2018 that's been published on the ICE website that says P1s can attend college full-time. So kind of building on that, prior experience, I started to analogize. I said, okay, well, I've got people on professional contracts who were able to go to school in their P1. Why can't we do that with people who are interested in getting NIL, which is effectively the same thing, right? You're getting paid for your services, for your name, image, and likeness as an athlete. And that's how I came up with the idea. And I want to say, to the best of my recollection, Amy, I reached out to you and I was like, "Hey, Amy, is this the stupidest thing I've ever come up with, or does it work?" And I think you told me that, we could probably roll with this. Is that how it happened?
Yes, and I think I also, because you do a lot of Ps, and I did fewer Ps before I got into NIL because I, as you know, primarily represent professional sports clubs, mostly Major League Baseball teams, but I also do a bunch of other sports. And so I was like, oh, we could also do the O1 because all of my, no offense to my Major League Baseball club clients, they're really cheap and they do not pay the attorneys to file their normal visas. They do them all in-house. So I didn't have a lot of experience with P1s. And so you and I sat down and brainstormed this together. And it turns out that while O1s are available to a minority of student athletes, they're actually not optimal for a provision in the regulations that you and I reviewed together, which just makes Ps a good solution for this if we could persuade the government to agree with us that, this is appropriate for international student athletes at the college level engaging in NIL. And we have had, I would say, a lot of success with a couple anomalous failures that we are litigating. So yeah, but I think the P1 workaround is the one that works, and so I give you all the credit for that because the O1 doesn't fit very well.
But I think it depends on the caliber of the athlete. And so I think before we kind of delve into, the P versus the O, which one is better, which one is worse, it might make good sense for us, because our audience is not necessarily composed of immigration lawyers or perhaps not even lawyers at all, to kind of just go back to the building blocks. So can you just walk us through very broadly what the requirements are for the P1A for an internationally recognized athlete and how we might qualify a collegiate athlete under that classification?
Sure. So, and this is actually an issue that has caused a lot of confusion, as you know, to athletic compliance departments because there are multiple kinds of P1 visas. So there are actually four different kinds of P1 visas. One of them is the P1 professional athlete visa. One of them, which is also a P1A, one of them is the P1A internationally recognized athlete visa that's not tied to being professional or amateur. That has nothing to do with those considerations. Then there is one visa that I actually have no idea what circumstance it would ever be used in because it's a P1 visa for somebody who's a member of a foreign league who's playing in the United States and they have to be ineligible for NCAA. And what we found is that athletic compliance departments are glomming onto that language and without apparently going through the general counsel for the university and telling people that they don't think they can be a P1 and play in the NCAA, which is completely wrong. And then is the other one ice skaters? I don't do those.
Yeah, I think it's for ice skaters. It's very random, but it's for ice skaters for ice skating shows, so like Disney on Ice type things.
Right. So basically, if there's a labor union, like in Major League Baseball, you have to have a consultation letter from that labor union. If there's not a labor union, there is no consultation requirement. And that's different from the O1 regulations where you have to get an expert in the field to talk about it. But basically, you have to show that this individual athlete is internationally recognized, and you could do that in a variety of ways and that they're coming into the US to play at an internationally recognized level of competition. The purpose has to be primarily to compete, and that's in the statute. And the language in the regulations does include ancillary promotional activities. And so we thought this was, I say we, Ksenia thought this was a good fit, and she's right. And the key regulatory provision that establishes why this is so much better than the O is that when you are filing a petition by an agent, so you can file P1 petitions by agents, by employers, by agents for foreign employers. And so what we've been doing in this circumstance is using the NIL agents as the petitioner, but you could use a collective as a petitioner. There are a variety of ways you could structure the petition. But when you have an agent as the petitioner, you include an itinerary, and the P1 regulations say that provided you have an event that is essentially the same or similar on the itinerary, you can add additional events without amending the petition. So for an O1, let's say I hypothetically have a client with a $1.5 million contract with a major sportswear manufacturer, and that O1 is approved, and then they get another offer from a different employer, I have to amend that petition. And that obviously increases the expense. The filing fees are expensive, the premium processing fee, which I would say in other countries, we call this a bribe. In our country, we call it a premium processing fee. Give me $3,000 and I'll expedite your case. I mean, that's just not workable. And so for the Ps, once you get the approval, you are able to just, as long as you have any promotional activity on there, just add whatever you want to, and it's considered to be within the scope of the petition. So the way, and part of the reason this was such a intuitive yet brilliant yet natural solution that Ksenia came up with is that one of the ways you show that an international or an individual athlete is internationally recognized, you have to meet 2 of a list of evidentiary criteria, and one of those criteria is prior participation in the NCAA as an athlete. So, you would think QED, if playing in the NCAA establishes that you're at an internationally recognized level of competition, if you're coming to play in the NCAA, that is so that you can come into play at an internationally recognized level. Yet we are having pushback from the government on this. So other ways that you can show you're internationally recognized are, oh gosh, what are they?
We have expert letters.
You can get expert letters.
Either
you
a
can get
media
right.
Person, or from an expert in the field, or
also from an association like the NCAA, they can give letters. For MLB, the MLBPA just has a letter on file with the government that they know about, and they don't have to file one with every petition. But that's not true for us at this level. And I'm trying to,
membership on a national team is another way that you can qualify.
Being internationally ranked.
Being internationally ranked anywhere in the international rankings is also
right.
Okay.
So, you don't have to be ranked high. You have to be ranked.
Correct. So I think to just kind of take a step back and really synthesize this down to the simplest terms possible. The P1A is what we consider kind of an entry-level sports visa, right? This is the lowest threshold in the realm of, these extraordinary ability type visas that is available out there, right? Which internationally recognized athletes sounds pretty daunting, but as Amy mentioned, for the NCAA athletes who have already completed at least 1 year in the NCAA, they've already got at least one of the evidentiary criteria qualified, and then they can do the rest with expert letters or with international rankings. And what we find is that most of these international athletes really have had some level of participation on, like, junior youth national teams. They do have some level of international ranking. So we find that generally the aspect of this of the requirements that focuses on the athlete and their ability is not difficult to meet. But where things get a little bit dicey for the P1A is that there's the second component, the second requirement in the law that says that what they're doing in the United States, their level of competition has to be at an internationally recognized level, which it becomes circular, right? Internationally recognized athlete competing at an internationally recognized level. But fundamentally, what immigration believes this to mean is that, the level of competition has a following, right? So they're looking at things like ticket sales, revenue figures, attendance figures. They're looking at broadcast media that are showing the games for this particular type of sport. And one thing that's really, really helpful for us right now is that ESPN earlier this spring renewed their contract with the NCAA for all 42 of the national championships, both on the men's and women's side. ESPN and its subsidiaries now carry the bulk of the TV coverage for many, many NCAA sports. And so we can point to those things to say, okay, if ESPN is covering this, then it must be at an internationally recognized level of competition. And for the most part, we've been successful in making those arguments. And I think maybe it'll help to kind of bring all of this together, because I know we've thrown a lot of legal terms at you. And sometimes it's hard for us not to talk in jargon because Amy and I are used to presenting to immigration lawyers. But Amy, can you just walk us through one of your recent examples for a P1 and just kind of talk about like the athlete, you don't have to give a name, but some of the types of evidence that you submitted and how that went for you.
So I do have consent from one of my athletes to use his name because he and his agent promoted this on social media. And I'm very happy to discuss this case. We filed and got the approval for the first P1A for NIL purposes for an NCAA golfer that we're aware of, Kieran Van Wyk. He's a South African golfer. He was ranked in the 70s internationally as an amateur. He won, and one of the criteria that you can meet is also winning a significant award in the sport. He competed on the South African junior national team. He had won awards and competitions in the United States, and he was approved for a 5-year visa, no problem. And even though what's interesting about this is there are different evidentiary requirements for professional P1As, and we just said in our petition he plans to turn pro after he graduates in like a year or two. And they gave us a 5-year P1, which means that he already has a visa for his conversion to professional golfing later.
Yeah. And so, obviously we talked about the petitioners, right? And I want to get into that a little bit more. I think, Amy, you were going with a little bit of jargon there, but fundamentally, each of these visa applications has to be filed by someone else other than the athlete who's seeking the visa. And that's what we call the petitioner, right? And really, in the P1A space, this is such a flexible term and a flexible category that I literally tell my clients just about any US person or US entity can be your P1 petitioner, and we can make it work under one of the available types of petitioners. And I don't even need to go into, all the different types. Just give me a US person who's willing to give a copy of their green card or passport to show that they're a US person, or give me a US organization. Now that may be an incorporated entity or it may be an unincorporated entity. For Ps, for track and field, very frequently, the track and field training group is the petitioner. But again, if we're talking about the NIL context and really this idea of like, we want to put every possible future activity that the athlete will generate income from under the umbrella of the same petition, then the agent petitioner scenario becomes really, really attractive. And so while an agent for the purposes of the P1 does not necessarily need to be what we typically think of as a sports agent, right? So somebody can be any US person or US organization can be kind of deputized to be an agent. I think that as a practical matter, it makes more sense if we are dealing with an actual, NIL agent and an NIL representation agreement that really fleshes out this idea that these promotional activities that, the NIL agency will secure for the athlete are in fact related to their name, image, and likeness. We really want to emphasize that nexus because one of the things that I think immigration has had trouble understanding with some of the cases that we've had some pushback on is they don't seem to understand that the commercial opportunities, so that $1.5 million contract with a sportswear company wouldn't happen unless this particular athlete had made a name for him or herself playing on the roster of whatever team they play for, right? I mean, I'm not getting an offer for a $1.5 million sportswear company contract because I'm not famous. But if you are, then, very likely that has to do with the fact that you are a student athlete at a particular university or that you're a student athlete, at all. So, it may be tied to a university, it may be tied to just your role as a student athlete because you may have transferred schools or whatnot. But that nexus between your role as a student athlete and the money that is being offered currently or will be offered in the future is really, really important to emphasize. So we have worked with NIL agencies. I think a similar sort of thing could be structured through an NIL collective. Obviously, there's some questions as to the kind of the future of NIL collectives, but I think that is is a viable way forward for us. So kind of moving on from the P1s, and I know that we could probably spend an hour talking about each of these, but but we really wanted to condense this into one module and, and make ourselves available, obviously, to stakeholders to get into the weeds, or perhaps, if you want to learn a little bit more about this, you can pick up our book, which is called NIL X Immigration. It's available on Amazon. If you search either of our names or just that on Amazon, you'll find it. It's like $5. And it's, a very simple, plain language explanation of all the things we're talking about today. But moving on from the P1, this is like one step up from the P1, right? So this isn't your crown jewel. This isn't the green card. This is the O1A extraordinary ability classification. So when we talk about the P1 and we talk about the O1, they're what we call non-immigrant visas, meaning that these are not green cards. These are visas that are issued for a fixed term that allow you to do very limited things that are approved within sort of the structure of the petition. So super, super important that everything that you want to do is actually included in the petition, because if it's not, or if it's not structured correctly, you may be looking at, engaging in unauthorized activities that, again, have this potential of triggering problems for you down the road. So, Amy, do you want to kind of take us through the O1A extraordinary ability?
Sure. And I will not get into Khazarian. I'm just telling Ksenia that. So because when you're an immigration lawyer, you just speak in numbers and letters, and nobody who isn't another immigration lawyer really understands you. And also we have these cases that become dramatic issues. But basically, the O1A is for a very small few percent of people who have risen to the top of their field. And so it's for aliens of extraordinary ability in art, in business, athletics, sciences. That's the O1A. There's a lower standard for artists and for motion pictures, television. So, we've got temporary visas from categories A through V as in Victor. Each visa category that's temporary or non-immigrant has requirements, and you either meet them or you don't, and there's no catch-all. So there are many situations where we have to advise clients, there is no visa for what you want to do. You just can't do it. And so basically, in order to show that you're an alien of extraordinary ability, yes, our statute uses the word aliens. It was written in 1952. The current administration is revising that a little bit and using non-citizen in their documentation. But basically, you have to show either that you won a major internationally recognized award, like a Nobel Prize, an Oscar, a Grammy, or for the majority of people who are not, out there winning Cy Young Awards, etc., you have to show at least three of the alternative evidentiary criteria, which include coverage in major media, lesser internationally recognized honors and awards, high salary, which obviously would not apply here to this, well, right now, as the athletes are moving into employee space, that's a whole other story, and various other criteria. But basically, you have to show that they're in the top few percentage of their field. And again, even though we've always had amateur athletes who would qualify at that level, for example, if you win a gold medal at the Olympics, you are clearly an alien of extraordinary ability in athletics. We've been getting pushback for NIL, basically saying if our NCAA Division I basketball players in the Final Four were so great, they'd be in the NBA. And it's interesting because the agency does not understand nuance. Ksenia made some great arguments about how the NBA has its own vertical, the G League, et cetera. And it's really a separate group of players, and you cannot compare apples to oranges. But so I think what we're seeing overall is just that with the advent of NIL, no one at any institution, nobody in the government is thinking about international student athletes. They're not trying to figure out how anybody can solve this issue if they're on a student or other visa. Nobody's considering it. Even we were discussing this before we got on the video, the House versus NCAA settlement that came out. Ksenia and I pulled the documents yesterday, and the class is just student athletes, as if they're all equally work authorized, which is not the case. At any given time, we've got more than 20,000 NCAA international student athletes. So
I think that NIL, adds just this additional level of complexity and nuance to an area that we were already struggling to communicate effectively to the agency, because people make make assumptions about how these things are actually adjudicated by the government. So people think, okay, I'm applying for an extraordinary ability visa based on sports. It must be that whoever is looking at my application has some understanding of sports. And that's just not true. They have no specific requirements as to background, as to industry acumen. And a lot of times we are having to explain what is painfully obvious to us and what we think is painfully obvious to just about any living, breathing human being. But nonetheless, we encounter pushback on these issues. And so when we are struggling to make it clear to the agency that a world record is in fact something that is both original and significant, then, getting into the nuance of adding NIL and NIL earnings and how that's all interrelated to the performance as a student athlete, that just adds this whole other layer of complexity that I think the agency, because they haven't articulated a specific policy, because the adjudicators haven't been trained on this issue, are just not well equipped to deal with it. And so, I think overall, I would say that the number of people, and we want to be very, very clear here, right? These visas that we're discussing right now collectively are available to probably maybe 10 to 15% of NCAA student athletes, if that, right? So this is not a solution that's going to be available to everyone, right? You may think, oh, I've got some awards, I've got some rankings, like, this is me, right? And fundamentally, particularly when we talk about the O1, we have the second layer of adjudication, right? So the first step is just a counting exercise. Okay, do you have awards? Do you have media coverage? Do you have a high salary? And actually, Amy, I argue scholarships on high salary and typically get it. But that in and of itself is not enough, because then the second step of the adjudications process kicks in, and that's a step where the adjudicator, the person who's deciding your case from the agency, is going to look at this whole bundle of evidence, and they're going to say, okay, does all of this taken together demonstrate that you have risen to the very top of your field of endeavor? And as Amy alluded to, this is where a lot of the nuance gets lost, right? So they're saying, well, okay, we see that you earned a, medal at the World Championship in basketball, but you're not playing in the NBA, so you haven't reached the top of the field of endeavor. And they failed to consider the fact that this particular athlete played on that team alongside other athletes who were, in fact, in the NBA and in the professional league of his country of origin, right? So if he's playing alongside these athletes, he's clearly good enough to be playing alongside them and representing his country at the World Championship. So a lot of this stuff about, these somewhat nuanced distinctions in sports are really difficult to communicate. And that's where, if you're working with counsel, do make sure you're working with somebody that understands sports. Amy and I are not by any means the only ones out there that understand sports and that do sports immigration. So I don't mean to, to say just only come to us, but do make sure that whoever you're working with really understands sports, because they need to be asking the right questions. They need to be strategizing the case correctly. And so that's super important.
I do want to add something though. We are not the only sports immigration attorneys in the country. That is true. But we are also, Ksenia is the founder of the Sports Immigration Lawyers Association, and it's a small group of maybe 150 to 200 attorneys that participate in this association and come to our conferences. And we've seen colleagues that we respect who are good lawyers lose these cases for reasons that we, may have counseled against. Like, you don't want to combine being an athlete with being an influencer, for example. So we have a colleague who had a NCAA D1 basketball player client who was at the very top of the NCAA, and he got denied partly on those grounds. And so meanwhile, I recently got an approval for a University of Michigan basketball player who is an NCAA D1 basketball player who is much lower than the guy who got denied. So who you choose as counsel in this moment when there is no policy, there is no guidance, is actually really important, because even small shifts in judgment around how to position these cases can change the outcome completely.
Yeah. So that's the O1A. And then I think like moving one level up, right, which is where we're at the crown jewel of immigration, right? This is the EB1A Extraordinary Ability Green Card. This is what is colloquially known as the Einstein Green Card. And the reason why it's known as the Einstein Green Card is because it is the green card that is available to the people who are at the very, very, very top. And typically, this is a category that's associated with scientists, folks that have won like the Nobel Peace Prize, folks that have really, really influenced their fields, not typically what most lay people think of as, as being something that's available to athletes, but in fact it is.
In fact, Melania Trump got an EB1A approval as a model of extraordinary ability.
Yes, she did. Different times, I think, different times. So these categories have become, I think in practice, even though the law itself hasn't really changed, in practice they've become a lot more restrictive in more recent years. And so this is the category that leads to a green card. This is it. You're going to be a permanent resident of the US. If you meet these qualifications, you're going to be able to stay forever as long as you don't do things that get you kicked out, such as, crimes or engaging prostitutes and things like that. So as we consider the EB1A category, it's actually very, very similar. If you look at the criteria side by side with the O1A, it is almost identical. I mean, almost, right? So as attorneys, we're always tuned to the nuance and to the very, very slight differences. And there are slight differences in the formulation of the criteria, but a similar bucket of evidence is available. So it is things like nationally or internationally recognized awards. It's memberships in associations that require you as a threshold of entry to demonstrate that you are, extraordinary at your field. It's, high salary compared to others, or other remuneration in the sport. So Amy, did you want to add something?
I did. Just to give you some context as to how difficult these visas are to get. In the professional athlete context, I file these regularly for MLB players, and USCIS will deny them if you're not in the top half of Major League Baseball. So we go through a variety of exercises to show that our clients are, in the top 50% based on salary, not above the mean, because the mean gets skewed up really high. But I had a baseball player denied many years ago. I think it was like 2014, 2013, because, quote, he'd only been an all-star one time. So they are not joking when it comes to EB1As. They will deny even professional athletes if they don't think they're at the very, very top of the field.
Yeah, and when it comes to the availability of EB1As to collegiate athletes, they are certainly available, right? In theory. In practice, we're talking about a very, very, very small segment of the NCAA international student athlete population, and we're really probably talking about primarily, I would say not exclusively, but in my practice, I've found that I've seen more people who qualify in the Olympic sports rather than team sports. I think that because of, again, some of the bias that we've discussed, where the US is also like very US centric when it comes to team sports. So, if you haven't played in the US pro leagues, you're basically no one to them. And obviously that's not the reality of the sports industry globally, but that is kind of their view. So in my experience, the EB1As are really more available to folks that are, in these individual sports. And while they're in the NCAA, they continue to compete internationally. So we're talking about, sports like track and field, which is my bread and butter. That's what I do the most of. We're talking about sports like gymnastics. We're talking about swimming. And if you're following, these are sports where we see a lot of NCAA athletes during any given Olympic cycle. We got NCAA athletes on the podiums at the Olympics, at the World Championships for these sports while they're still in the NCAA, right? And that kind of crossover really lends itself well to the EB1A application. And so just again, to give people some practical context, my first EB1A application in the NIL era was for Cameron Rogers, who was a hammer thrower at the time at my alma mater, the University of California, Berkeley. And at the time that I filed for her, and this was very early in the NIL era, we filed for her in the fall of 2021. So literally the announcement came out in July. I filed her in October of 2021. You know, she was very nervous, but I was like, Cameron, we've got this, because Cameron at the time, and you know, since then she's gone on to win an Olympic gold medal. She's incredible. A silver medal at the World Championships. But she is also, at the time that I filed for her, she was the youngest hammer finalist in the Olympics ever. So we did it based on that. We did it based on her national championships. She had already picked up a couple at the senior level. We did it based on her competition at other major sort of continental level championships, and her membership on her national team. World Athletics, the international governing body of the of track and field, is an absolute gold mine for statistics and, you know, really useful things that I work into my applications. So very luckily for Cameron, who was, you know, in the midst of a very important athletic season and also her last year in college, you know, I kind of was able to take the weight off of it and pull a lot of the information from public facing resources. So, you know, while I don't think this is necessarily the only standard, so I don't want to say that, you know, that people should be using this as the foolproof litmus test. But if somebody's pretty Googleable, we may want to talk, right? I think that that's a good kind of indicator, right, Amy? What do you think?
Our good friend Karen Woolman, who is one of the attorneys that you should want to represent you if you are interested in this type of visa, she always says, tell me what you're famous for to the EB1A people who come to her office. And if they can't tell her, she's like, you're not an EB1A. But I'd love to talk about our litigation, Ksenia, because going back to how the government's pushing back on these visas, Ksenia and I filed a lawsuit in New Jersey on a couple EB1A denials, and I think you should take this away because it was your client that was wronged.
Yeah, so this actually predates the NIL era, but is kind of a decent illustrative example of how petty the government can be in adjudicating these visas, right? So this was another track and field athlete. He's a 400-meter runner who is currently ranked #1 in the world. I'm super, super proud of him. But at the time, he was having a rough season, and things were just not going well for him. But a rough season for a guy like him is him being ranked very, very high nonetheless. So he had national championships, he had continental championship podiums, he had multiple national team memberships, he had a professional contract. So we were, you know, able to establish, I think, at least 5 criteria that we were credited. And then the government came back and said, well, we see that all of that is all fine and well, but he's only ranked 430 something in the world. And we don't believe that that is the ranking of someone who is, you know, sufficiently extraordinary or someone who has reached the very top of his field of endeavor. And I call Amy and I'm like, Amy, I know we're lawyers and we're bad at math, but this is really bad math, because he was ranked 430 something out of 12,000 ranked athletes, which puts him squarely in the top 5%. Right. So I was forced to file a federal lawsuit. You know, imagine the government is a defendant in a federal lawsuit where my claim is basically that a federal agency is not familiar with basic arithmetic, and, you know, and that they are denying this person who is ranked in the top 5% of his field of endeavor, saying that he's not sufficiently extraordinary. Now, Amy had another person on that case, so we did a multi-plaintiff lawsuit where we connected this math genius, and they filed together. And so, Amy, you were the one that was speaking to the AUSA on the case. So when we sue the government in federal court, we we typically communicate with the AUSA on the other side. And what did they have to say about USCIS math?
They immediately withdrew the denial and issued an approval. before we went any further in the case. So our MIT genius who created a new field of geometry and was working on Wall Street, they fought that one. But for Ksenia's client, they caved immediately because we could show mathematically he was in. I think when we compared it to, because basically what we said in our complaint is you either have to compare his ranking to all track and field events, which is the 12,000, or you need to look at his individual ranking in his individual event. And either way, he's in the top few percentage of the field.
Yeah.
So we could mathematically show that they were wrong. So that case immediately approved. Wall Street guy, he actually, and this is what we've been seeing from USCIS, the government pushes back on these cases. And so the Wall Street guy, instead of adjudicating his case, and this guy was brilliant. He had letters from all over the world. I mean, he's like an MIT super genius working on Wall Street. But his attorney who referred the case to me for litigation had also filed something called a national interest waiver. And at the time, he could get a green card through that. And in order to get us to drop the litigation, they expedited his green card on the national interest waiver and approved it in like a month and a half so that it would moot out our case and we couldn't go forward with the lawsuit. So, but we've been filing these cases now for years. And the trend has been in the beginning, they immediately caved and approved whatever we sued them over. I loved my O1 denial for the Real Madrid Academy soccer coach who taught Real Madrid methodology in 66 countries. And he wasn't good enough in Real Madrid, was not an organization with a distinguished reputation. Like I cannot with these people. So even though we produced documentation that they were the FIFA club of the 20th century, et cetera, I mean, they're Real Madrid. And he taught at Real Madrid University, which is a legitimate joint venture between a real accredited university in Europe and Real Madrid's foundation. It was crazy. But we've seen over the years that the government has started pushing back, regardless of how stupid the decisions are. So, Ksenia, would you like to just pull out that weight class coach case? That was amazing.
Oh,
I
yes,
love.
yes. We've had to go to federal court on a denial to a judo coach who groomed the world champion in judo. And the government came back and said, well, we see that he was the world champion in judo, but he only won a medal in his own weight class, so that's not good enough. And my complaint literally said it is not clear to me how the athlete was supposed to shapeshift into multiple weight classes in a single world championship competition. We get snarky with them, and to give some cover to Berkeley, because my alma mater, I have to stand up for them. These opinions are truly ours and ours alone. Like we don't want to throw Berkeley under the bus here. We do have to kind of get adversarial with the government every once in a while. As a means of advancing the interests of our clients. But I do want to make clear that these opinions belong solely to us.
We do get a lot of questions from clients about whether or not the government will retaliate against them for suing. And the answer depends on what agency you're suing. If you sue the State Department, I think retaliation is a real possibility. But suing USCIS, you're dealing with the Office of Immigration Litigation from the Department of Justice in Washington, D.C., or the local U.S. Attorney's Office. They don't want to deal with immigration's nonsense. They have better things to do with their day. And with the agency, I mean, by the time this gets escalated to somebody at a high level in the service center that issued the decision, the officer that made the stupid decision is completely apart from it. I feel like we actually get better results by being aggressive and suing. And I don't know what your opinion is on that, Ksenia.
Yeah, I mean, I think so far we haven't seen any evidence that there's retaliation. I mean, ultimately, the purpose of suing in federal court when it comes to, any kind of NIL or not NIL related sports case is to get the case in front of hopefully an impartial body, because the appellate structure of the U.S. Citizenship and Immigration Services is such that the appellate body that they suggest you appeal to is merely another department within USCIS that is very unmotivated to overturn the decisions of the adjudicators. In fact, for
They have a mandate to uphold them.
Right, for a fee of several $100s, I think now it's close to $1,000, and a wait of a year or more, you are 95% likely to see that initial decision be be sustained. So I think, you know, we have to kind of think strategically about these cases, but just kind of going back to NIL and NIL specific issues, you know, I think of these P's and O's and EB1s as a Band-Aid solution. That's what I called this module. It is truly a Band-Aid solution because, you know, these are still imperfect applications, right? They still don't give full access to NIL to everybody that wants to have access to NIL that is potentially marketable as an international student athlete. And, you know, and really where I think some of these categories, you know, might demonstrate to be truly the Band-Aid, right, is if the House settlement goes through, and just to kind of be, you know, to go back to what that is and what its implications are. So the proposed settlement in House v. NCAA is talking about the possibility of direct payments that are going to start from the schools as early as the 25-26 academic year, okay? And so whereas NIL has so far been an ecosystem where schools are not directly compensating the athletes, right? That at this point in time, you know, it's either the NIL collective or it's some third party, such as a private sponsor or something like that. When we turn this thing into a direct compensation model, first of all, we're going to have a bunch of people that are going to be on rosters that at schools that are going to be, you know, ready to directly compensate their athletes who are not eligible for O's, P's, and EB1s. I just want to be clear that not every athlete on every D1 NCAA roster, even at, you know, top schools, is going to be eligible for these solutions. So let's pretend we've got somebody who's not. Let's say the school, you know, is ready to make their direct payments. We have a major problem here because, you know, the F1 doesn't work. Well, even if you could move these athletes to a P1 or an O1 or an EB1A, you know, we have kind of some practical issues here. For at least the P1 and the O1, those classifications have to be filed with a petitioner, right? So, you know, typically in a direct employment situation, the petitioner is in fact the employer, right? I have a really, really hard time believing that the schools are going to go out there and start petitioning for O's and P's for their athletes. I just don't see it.
I've spoken with a university about this recently, and they're, you know, a lot of universities tend to do certain things in-house. They do H-1Bs for professors, they do EB-1B outstanding researcher green cards or professor green cards. They do some EB-1As for their faculty. But I was told by the university, we like if an international student athlete is not an F1 status, we wash our hands of them. Like it's all on them and their petitioner, and we're not doing it. They're not supervising it. They don't want to be involved in it. They're not referring people to attorneys. They're just not going to have anything to do with it. So I agree.
And that's a problematic perspective, right? Because even if we're trying to say, okay, fine, we're going to let go of the kids that aren't O and P eligible, right? Like we're just going to, the bench warmers, we're going to say, sorry, you know, this is a situation we didn't see coming. We're going to have to cut you, okay? But let's say we've got some kids who are potentially eligible for that O or P transition. You know, if the school says we don't want to, even though we're technically the employer, right? We don't want to file this O or P petition on behalf of this athlete for them to continue to play. Let's say the agent, let's say the NIL agent is ready to file that petition. That petition still needs to be authorized by the school. So the school still needs to say, we hereby authorize NIL agent so-and-so to file this petition so that we can directly compensate our athlete on our football or basketball roster. And again, you know, from a liability standpoint, I see maybe departments getting real uncomfortable with that idea. So I think there are a lot of practical hurdles that are going to have to be cleared. Moreover, you know, we have this concept of I-9 compliance, and there's going to be, you know, another session, you know, that speaks to that in a little bit more detail. But as an employer, the university has to go through a process by which they document that the folks that they are, you employing, that they're directly compensating, are employment authorized in the US. And, if those folks are still going to be on their F1 visa, that's going to be a situation where the university is not capable of complying because there's not an appropriate, work category, right? And all those things that we talked about, in the NIL context, these NIL workarounds that we talked about in our preceding sessions where, you go and do NIL back home, passive NIL, none of that is applicable here because we're talking about direct payment. Like direct payment is very clearly an employer-employee situation, at least as far as immigration law is concerned. The
Right.
DOL may take a slightly different position. The IRS might take a slightly different position. But as far as immigration law is concerned, if you are on payroll with these people, you are employed.
They're employee, yeah.
And you need appropriate employment authorization for the employer in this context to undergo I-9 compliance. So a lot of really, really complex issues coming down the pike with this House settlement that it appears that class counsel is perhaps not considered, and that has not been brought to their attention. Perhaps, we hope, some of this may push the needle with the government to issue some kind of solution. Amy and I have been involved in some advocacy efforts and are working on a few things that we think, could potentially move the needle here. And at least, as another Band-Aid type solution could cover some of these scenarios. But again, everything that we're talking about is really imperfect. And we were just talking offline yesterday about, okay, so let's say the House settlement, the provisional settlement then turns into a final approval in the spring. What do we do for the internationals? And we were kind of brainstorming about this yesterday, and the answer is we still don't know.
Right.
And if we don't know, nobody else knows.
Pretty much. I would like to add to that, obviously Ksenia and I are in the business of immigration representation of international athletes, and my practice also involves a lot of other areas. I do medical, I do, high-end technology, I do all kinds of things. But from the very beginning, Ksenia and I have really been outraged by this from 2021 because the fundamental issue is there is no level playing field, no pun intended, for international student athletes because no matter what, you're not going to be on parity with your US athlete, teammates. And the reason is I've told my NIL P1s and O1s, in order for this to be worth the filing fees and legal fees, you have to have at least $10,000 of NIL on the table. Not everybody's going to have that, but just the fact that international student athletes would have to pay to get this Band-Aid solution, it's not fair. It's not just, there's a fundamental lack of parity. And so early on in, I want to say 2021, we pretty much immediately flagged the issue. We started working with coalitions of various people. So organizations of coaches, athletic directors at universities, and assistant ADs at universities. And what was interesting was nobody could agree on the solution in this. So we ended up, Ksenia and I and a couple of our colleagues, writing text for a bill for Senator Chris Murphy that went nowhere because hello, Congress and our administration not passing immigration bills, even though you would think like your home state university athletes would be something Republicans and Democrats can agree on. No. We have communicated directly with the agency, both the agency director and the chief counsel, Ashley Tabador. Unfortunately, the USCIS chief counsel's background is actually as an immigration law judge deporting people. So she has no understanding of business immigration or, it's just really not her area of specialty. She has been reasonably responsive to us, but not in the sense of issuing any policy. We've been told that regulations will not be forthcoming, period, until there's a new administration. And around the time of the Alston decision, ICE's SEVP, which is the Student and Exchange Visitor Portal that tracks students, F1 students and J1 exchange visitors in the US, they sent out a bulletin saying, we will be issuing guidance. We'll be watching what happens and we'll tell you what the what is. Crickets. There's been nothing since then. And I'm sure you talked about how the NCAA initially said, oh yeah, international student athletes are included. And then they were like, oh no, talk to a lawyer about this because we don't know. So it was just really disheartening to look at that class settlement and see that the class is student athletes because the presumption is all student athletes have equal work authorization. And that's just not true.
Yeah, and the cynical end note to all of this is that international student athletes in all respects in the NIL industry have really come across as an afterthought for many of the decision makers, and we find that to be a really unfortunate state of affairs. And we continue to fight for the rights of international student athletes and to try to level the playing field at least to some extent. But it has been very certainly an uphill battle so far. I know we're almost out of time. Amy, do you have any closing thoughts and comments? Because that was mine.
I mean, there has to be a solution, and it's not clear where that's going to come from or how much of a train wreck is going to occur before we get there. So, our interest, because at the end of the day, international student athletes are held accountable by the Department of State at the consulate when they go to renew their visa, or by USCIS when they apply for a green card. I mean, we're advising people in an abundance of caution. And I think the universities in particular are going to have, I mean, what we've seen just from the universities we've been interacting with are some are very conservative, some are willing to push the envelope. You know, I just think it's going to be all over the map and a total mess. And it's going to have to actually cause problems before anything happens because we've been pushing this hard for years. We've connected with the right people. We've tried to advocate. And in a way, I want to say in a way, like it's not in our own self-interest because obviously we're not getting paid so that F1 international student athletes have the same access to NIL as US student athletes, but it's fair and it's just. And we didn't go into this, if you go into law for the money, you're not an immigration lawyer. Immigration law is the lowest paid area of law. So we really care about this issue. We're passionate about it. We care about our clients. And we're concerned that this kind of disaster from the NCAA and the courts and plaintiffs' counsel and the government is going to end up impacting foreign students. And that's not fair. Again, it's not fair. I mean, I hear my mother saying nobody said life was going to be fair, but this is not a way to run anything.
Yes.
First
So
world nation.
it's stunning from my perspective. I've spent my life in commercial litigation and in IP world, and it's a world of ambiguity, but nothing like this.
Yeah.
This seems beyond ambiguity into the world of randomness at times. It's a good wake up call for people, families, students, and administrators to look for at least some acceptable level of ambiguity, not what I'm hearing out of this. So it's hard to really scare me. And this is the second time Ksenia has scared me with programming. So this is no way to run a program.
Well, and on top of that, and I'm sure you've already talked about consular non-reviewability, Ksenia.
Yes.
Yeah.
Former
You have
panel.
no review. So if one person decides that you violated your status, that's it. You can't return to the US. If that F1 student wanted to get a P1 visa, they may be precluded from getting a P1 visa and coming and playing professionally in the NBA. Normally, I have to be honest, if you're a major league team, you can get your people in regardless of what they've done. Most of the time, the exception was that one guy from the Dominican Republic and you remember Tampa Bay Rays, I think. Yeah, that was bad. But in general, they're able to get people in. But let's say you want to come back and, I've had athletes who end up getting a master's degree and working in business because once they get out of their collegiate program, they do something else. And that could negatively impact somebody's ability to immigrate to the US forever, to visit temporarily, to work here. And that's a problem. And there's nothing, I always say that being an immigration lawyer is like trying to use right-handed scissors when you're left-handed. It kind of works, but there's a lot that just doesn't work.
Indeed.
That is a wonderful.
Sorry.
So that's a wonderful image to leave us with, the right-handed scissors. So
That's it. And I think we're out of time. So, Wayne, do you want to wrap us up here?
I do. Well, thank you both. Again, I know you're donating your time to help others on this, and I appreciate it. Berkeley appreciates it, and I'm sure the students and families will. So thank you.
Thank you so much.
Our pleasure.